Today's guest, not to be confused with the 7'1" Swedish European professional basketball player, joins us from the chilly hometown of the second-rate NFL team, the Minnesota Vikings. He's one of the industry's most respected and very first plaintiff's attorney, brave enough to put his career on the line by joining the other two Retireholics on the show today. He's got a no bullshit, speak his mind attitude, which we all can certainly appreciate. He's a founding member, origination specialist, and subject matter expert of Nichols Casser's ERISA and financial services litigation practice. Ladies and gentlemen, Carl Engstrom.
Thanks.
That's really important.
Carl.
Clap, 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 clap.
Let's go through. We're going to play some games today, Carl. So just make sure that you know exactly how everything's working. We will be playing acrosin, which means you can't say any initialism or acronym. You can say my name. That's okay. And for everyone out there and you guys here, Carl, again, does not like to poison his body with alcohol. Kudos to him. So we're going to do something new and fun today, everybody. Carl's got a friend. He's got a little acrosin buddy, Nick, who we're going to put in a little box up there. And every time Carl does a penalty, Nick will drink for him. I'm thinking
This should be the rule going
Wait,
forward.
so I just have to know, like, who is Nick? Nick? Who
There
are
he
you?
is. There he is.
All right.
There he is.
There's Nick.
So I've got, I mean, Nick actually does need an introduction, unlike some folks. But so not only is Nick a good friend, he fought his first professional MMA fight in 2003, the age of 22. He retired with a record of 38-14-1, 38-10-1 if you don't count his last four fights. 4 years into fighting, he decided he needed to diversify professionally and enrolled in law school at the University of Minnesota. Graduated in 2009, got knocked out a week before he took the bar, passed anyways. Today, Nick is the owner head of Casey Jones Law, specializing in railroad worker disability discrimination and personal injury. Notably, he, on July 1st of this year, procured a $44 million jury verdict in favor of his client, of which his client will collect $300,000 because of generous federal limits on emotional damages and punitive damages. Nick.
So does Nick get to keep the rest?
This introduction is mine out of the water.
I don't know. Maybe it goes into Dogecoin, I think, and maybe an account somewhere. I'm not sure.
Can we all get a rating on that intro, please, in the chat bar?
Yeah, that's a good one.
Smoked, Justin.
I feel like that's
Smoked
one
me
of
for sure.
Justin's. That's one of Justin's fake introductions, but it was all true, I'm guessing. So that's a pretty gnarly story. Wow. Well, we are honored to have you here, Nick. And so we will let you know every time you need to drink on Carl's behalf. We will also be playing Chat Bar Champion. So, and I'm thinking Nick can get a vote too. So Carl and Nick, keep your eye on that chat bar a little bit. You'll be voting someone into the semifinals for Chat Bar Champion at the end of the show. There's no rules to that. Just whoever floats your boat, whatever you're into. Headlines. Let's get right into headlines. Brandon, graphic, please. Yes, I love that.
It's good, B. Just good.
I was on a call earlier this week. Don Trone had an announcement to the world, to the industry. The Center for Board Certified Fiduciaries is affiliating with Wake Forest University to provide the industry's first executive education certificate in fiduciary studies. You can find out more at www.c-bcf.com. Great URL, Don, that you picked up there. For more information, anything. Oh, yes.
Ding, ding,
Good.
ding.
Going straight from
Mark, you
bottle
on the
tonight.
buttons?
Yeah, I do have to make one mention though. I think Brandon has officially cut me off of any other button than just your faces because there's nothing else there.
There's like four.
Bastard.
Anything that Don Trone is into, I think is worth following. So check it out. We got the new 2022 401k limits today. Chad, where did they go? Up, down, sideways? They went up.
They went up.
Great.
Yeah.
All of
I think
them.
he, all of them. No, that's
All- actually all of
I
them.
believe that's a first. Also, the first time it happened in $500 increments.
Catch-ups didn't go up.
catch-up stayed the same. Deferrals up to 20,500. So you'll see everyone and everyone's mother posting that on social media. So I'm sure you'll
Can't
get
wait to go into LinkedIn tomorrow and everyone thinks they're the only fucking person that figured that out. Yeah, great.
Wow.
Yay.
Thanks for letting me know the
To be-
limits came out.
To be clear,
Yes,
I don't
Carl.
think the catch-ups are going to go up for a while because America hates Gen X.
I like Carl.
Sorry, JD.
I like Carl. A Census and Newport group merge. I don't think this is really an acquisition. I don't know. Most articles I read are calling it a merge. Yes, Chad?
Nothing. I'll save my comments.
No, so that's funny. I've got my own notes here in my notes telling me to go find the stats on it and go. Got to make them pretty big. I'm wondering, do they have the most plans of any record keeper at this point, or is someone like Paycheck still ahead of them?
The release said 150,000 plans. Not
think that would
obviously
put
not
that-
just in the defined contribution space, but they got, I'm not going to say all the other acronyms, but they got a lot of plans full of acronyms.
Do you think that Newport Group will remain a name, or will it be dissolved? We will only know a Census at some point going forward.
I think, remember Newport Group rebranded when Verisite purchased them. And they did so because Verisite had, in my opinion, had
Yes.
such bad track record from a service perspective. And so they rebranded Newport Group, who had a good track record.
Well,
I think it'll go
Hackler's
away.
Hackler's got a great branding name for them. So Nuisance would be good. Good one, Hackler. Their CEO at a Census, David Musto, I hope I'm getting that up, Chief Executive Officer, had a little quote I'm going to read for you. Is it okay if I read from you? Because I want to get everyone's take on this.
Yep.
He said, quote, "We've used acquisitions in a couple of ways, but I'd start with our focus on growing client relationships and driving more value in the market through investment in our own capabilities, products, and solutions. We've been very successful doing that. Where do we see opportunities to accelerate the expansion of capability sets or to access segments of the market that we've not previously tapped to create additional scale? Those are the opportunities that appeal to us." Why do CEOs talk like that? I don't even understand what the fuck he's saying. Oh, got to drink again. Do they all go to some? Did they go to some fancy CEOs? Gosh, son of a bitch, school to teach them to talk in nonsense?
I don't know, JD. Takes one to know one, buddy. What do you think about that?
Yeah. And it was a release statement. You really think he wrote it? Good point.
I just don't understand. I'd just like to hear about it in normal plain English. That would be my.
He wants to make more money.
Than the stupid corporate
What-
blabber.
What access did they get through this acquisition? Like what portion of business did a Census not have a fingertip in
Yeah.
that they now got in through the Newport acquisition?
I'll tell you, Chad, they got the opportunities to accelerate the expansion of their capability sets.
Duh.
That's what they got. Let's see. We were told that when Build Back Better was slashed and all the retirement provisions were taken out of it, I think it was Mr. Brian Graff that said, well, at least we're not, what did he say? Eating our vegetables and not getting our dessert, because they did not take with it the mega backdoor raw stuff. That stayed status quo. Now we're learning that maybe some of that shit is back on the table. So in Graff's terms, we have to eat our vegetables and we don't get any fucking dessert. So that sucks. Yes, Chad.
I was just saying, this is like a little birdie whispered this, because the only place I've seen it is from the man in here himself, Mr. Nevin Adams. And there, he says at the bottom, I haven't seen any legislation from it. Like there's no write-up. He hasn't seen anything. So I think
Nothing's
it could all
gone
just
through
be another talking point.
Nothing's gone through, but Nevin and those guys are writing articles, so they're concerned about it. They wouldn't put it out there if it wasn't a thing. They're not just making it up. Goldman Sachs, there's a lot of headlines today. Goldman Sachs on a census.
Don't worry,
yesterday.
Carl. Don't worry, Carl. You'll get to talk at some point. Don't worry.
Well,
I have
Carl can-
I have so many opinions about the.
I believe
record-keeping
Carl
effort.
can chime in on Goldman Sachs in a variety of ways, so we'll let him get involved in this one. Goldman Sachs and a census are coming out with a small plan solution that they advertise to be tied to digital financial wellness and digital planning and advice. So I'm just bringing this up for everyone out there. We don't have to go into it in detail. Keep your finger on the pulse of all this stuff. It's happening, and it's happening in real life, advisors, and I want you to pay attention to it. But we've talked about this before, so I digress. We don't have to go back to it. Carl, are Goldman Sachs, are they a fan of you, those guys?
Well, we are currently suing them.
Yeah, that's what I thought.
We're in the middle of a lawsuit, so I believe
Maybe not. Maybe not.
Now, in all fairness, our case has nothing to do with their digital financial wellness product with the Census. So
Right.
it's instead for, just use of proprietary funds and self-dealing are kind of our huge. But yeah, that sounds great. Is there even an app, JD, with their new product?
There has to be. There must be an app. Ooh, is that we call that a?
Those are
we-
applications.
all right,
No.
It's an abbreviation.
No, but I
Nick's
was
gonna drink anyways.
Nick drinks, it
overruled.
counts.
Calm down, people. Hold on. I was overruled on that many moons ago, so I don't press the button on that one anymore.
But I can still drink, right?
You
Sure.
can drink anytime you want, Nick. Yeah. You can drink
Yeah.
anytime you want.
Good.
But
I see you
Carl
up
may
there,
go
Nick.
off the
I see you
rails.
drinking up there.
Carl may go off the rails a little bit. And then in a more pop culture sense, and I'd love to get Carl's take if you even paid attention to this. Mark Zuckerberg, Facebook now is no longer Facebook, the corporation is now Meta. And Zucks has introduced to the world through about an hour-long presentation, the metaverse. Did you see this at all, or have you paid attention to it at all, Carl?
I mean, a little bit. I mostly just saw people make fun of it on Twitter. So from that, I have some correct and some parody versions of what actually happened. But didn't they, in fact, not check the logo and it's identical to a migraine drug? I feel like that's a bad start.
That's
I think
telling.
it's just that classic infinity kind of thing.
Infinity, yeah.
Mark, are you excited for the metaverse?
Honestly, I didn't see anything about it until about 30 minutes ago when you sent that email.
You mean 3 days ago when he
I-
sent
Yeah, he sent the email. 3
Yeah,
days ago.
I wasn't paying attention to it at all. I think I had heard something about it, about Meta and all that, and I was just kind of like, I don't really give a shit. I don't have a Facebook page, so I just kind of let it slide. And now I realized, and I watched it, I was like, if I'm being honest, I'm like, there's some pretty cool applications to this whole world that you could create, and the ideas that he was bringing out were, again, I'm not the most technologically sound person out there, but I was kind of like, well, that's crazy. I mean, people thought we'd have flying cars by now, but instead Mark Zuckerberg's just gonna fucking turn us all into holograms and we're gonna be zombies at some point. So whatever.
Sadly, though,
That's fine.
we're not going to be
but-
alive long enough to see it come to fruition.
But I will say,
this is-
watching Mark
Not
Zuckerberg
done.
talk I don't know about
Creepy.
that guy is just he's built different.
Mhm.
He's creepy.
Alien.
He's creepy.
If they could make it
Um,
like Ready Player One, it'd be amazing.
I was just going to
They're gonna
ask
be
you
there.
that, Justin. I was going to ask you if you'd seen Ready Player One and if you felt like life in Ready Player One would be fun for you in the future.
Fucking weird, dude.
That would be
I don't know.
cool.
Chad,
It'd
Chad
be
says
cool if you didn't
yes,
get
he's all
addicted
for
to
it.
it, right? And you could actually have human interaction. But if life is anything like it is in the movie, hell no. God,
Well,
Oh
I've
man,
heard-
I'd stand up on that thing and I'd run all day and I'd be a professional football player and race cars all the time. That'd be awesome. You guys
They
know
already
how
have
accident
the
prone I am, but I wouldn't have to.
Oh, you
on
can hit the
track.
ball 300 yards, Chad? You can hit bombs? Show me your short game. I want to see your short game. I know you three-putt, Chad.
I know you three-putt, Chad. Okay, let's go straight into topic number one. And of course, you could guess what this topic is going to be: 401k lawsuits. So I'm going straight to you, Carl. How do you sniff these suckers out? Do you have a bunch of people sitting in cubicles, sifting through, scouring through 5500s? And then what step do you take it to the next step? How does this start, this whole suing a company?
So it's evolved over time. So at first, when we were first starting this, practices were pretty bad. And so it was literally me, because I was a financial advisor for 6 years, and then went to law school. And so it was me just remembering some of the mutual fund companies and looking up their plans, like, oh, Putnam. And then it was like, oh, Putnam has 30 Putnam funds in the menu. It's like, that doesn't seem consistent with fiduciary duties. So it was, at first it was just like the lowest of the low hanging fruit. In fact, I had one day in October 2015 where I just Googled biggest banks, and I got the list of the 50 biggest banks, looked at their 5500s, and that turned into 4 lawsuits that settled for over $100 million combined. So that was the process originally. Now we have 3 or 4 people that we take the data set from the DOL every single year. We process that. We've created formulas so that we can look at the rates of return of all the different plans. We create lists of, now we then segment them based on standard deviation and try to find low return plans vis-a-vis the risk. We're looking at new employee stock ownership plans. So yeah, we're looking, but it usually starts with a theory of who a bad guy is. And then from there, we figure out ways to sort of filter the universe.
When I started to do my research on you, that was what I was shocked at. That's where my eyebrows got raised, was when I saw names like MFS, Goldman Sachs, John Hancock. Oh, shoot. What does that stand for? Massachusetts Fund something?
It doesn't stand for anything anymore, so I don't know what that means.
Right. And I was tripping. I was like, damn, dude, this guy's going after our very own industry. And so you just mentioned it. It was as simple as that. You poked around enough to know, why does Hancock have all Hancock funds? Right. And that was enough for you to laser in on it and go.
Right. I mean, I would say that we have to then go beyond that, right? So we have to sort of look at what the participants' experience is, what are the funds they're investing the most in, and how is this manifested itself? So with Hancock, we found that, almost half the assets were in their target risk funds, and that those target risk funds were basically just a mishmash of their funds, and effectively just taking 50 bips out of your returns without any real alpha. And so that became kind of the focal point of the case, in addition to just the all proprietary lineup. So, we dabble enough in Morningstar to be a little dangerous to ourselves and others. So we usually refine the theories, but yeah, it starts with something pretty simple, like what in the self-dealing cases, what their products are using, and whether a objective prudent fiduciary would ever use those products of a plan of that particular size.
What's interesting too, Carl, is like, we're pretty, I love how Nick knows when to drink. He's solid. He's got it covered. I love it.
It happened a little while ago.
We have industry people that watch the show, that are in our very chat bar right now that may not, like your approach to these types of things. It was funny when you're talking about Hancock, or I was thinking about it. If I worked at Hancock and I was a participant in the 401k plan, and we were using not Hancock target date funds, I understand fiduciary and responsibility and all that kind of shit, but part of me feels like that'd be kind of weird, wouldn't it, Mark? Like, why are we not using our own money management funds? Like, it's the company we fucking work for. Aren't we proud of what they do?
Yeah, I mean, think of like an Apple employee using a Samsung, right?
Right.
Like it has that same feeling, but I get that this is very different, very different.
Yeah, but what about like a Google employee having to use the Pixel? I think that's a better analogy, right? Like, another word, I mean, nice. And another word, and also if it's true they don't have any actual money managers, they sub-advise anything, but maybe for people on the investment side, that's perhaps it. But looking at Hancock, there are actuaries, accountants, administrative assistants, et cetera, who have nothing to do with the investment products, which are just part of their variable annuity line. So to me, the idea of it all being Hancock is stuff there is a problem. I sort of can understand that argument better when we start talking about like MFS or Putnam, where
Goldman, Goldman Sachs. I mean,
yeah, Goldman's massive. Like only 2% at most of Goldman has anything to do with the mutual funds. But on some of those money managers, they only have like 1,500, 2,000 employees, and I can kind of see the case. Except when I've talked with the employees, again, the majority of them are doing back office processing, customer service, and the notion that they should get stuck with, second, third rate, proprietary, actively managed funds just because they work there, I think kind of sucks.
Can I ask you, Carl, to challenge you, and I want an honest answer, and I feel like you're an honest dude with this stuff. Let's say that those proprietary funds were in line with expenses. Like, let's say you looked at them, you analyzed them, and the expenses were not out of whack. Would you still attack it? Would you still go at it?
We've turned down a number of cases and not pursued them because we thought that the offerings were generally competitive. We made it a strategic decision. Not to go after Vanguard, not to go after T. Rowe Price, because we thought that, in T. Rowe Price's case, they were really aggressively switching to CITs in order to keep the costs as low as possible for employees. We felt like there was enough.
Thank you, Nick. Thank you, Nick.
Thank you, Nick. And again, we maybe could have brought that case. We err on the side. It's a massive risk taking a case, a massive financial undertaking. So we've certainly turned down cases based on views that
can I ask you
were competitive. But even in cases where the fees might be competitive, there could be other problems. Which is the case.
I was just going to say that it seems like in some ways you're almost being an investment advisor and looking at the strength of some of these providers' offerings and targeting them based upon that. That it truly is about investment prudence, and you're going after groups specifically over that, let alone less about process, you started to touch on fees there, but maybe getting back into that fee realm with proprietary funds and appropriately pricing their cases. But it seems like you really are analyzing the investments and going after groups for that reason.
Actually, it's true that we are analyzing the investments and their merits, but I'd say that we do that really with a very large focus on process. In other words, the thing we're thinking about is what process could have led to this outcome? How could this be? Could this have happened without a piece of biased advice or laziness behind the wheel? So like my job is to make it so that usually in a lawsuit, you file the complaint, it gets past the motion to dismiss, and then there's discovery, and you get all the emails, all the everything. And the comment I've been getting since we started this practice group 6 years ago is, how is it that every time the discovery comes in exactly as you predicted in terms of what their motivations were and what happened? In other words, we're just thinking about how the organization existed, who had the power, why a decision was made, and we're looking for parts of that are broken. And to me, as someone who has worked at a whole bunch of places and who generally loves to think about how organizations work, it has to sort of fit together, and it usually does. We're wrong a little bit of the time. We've had to voluntarily dismiss cases where it didn't line up the way we thought. But actually, yes, we're looking at the investment merits, but the thinking about John Hancock is the thinking about like, was there really could this have resulted from an objective process in which they were trying to define the best target risk fund for their employees?
I think it might have been, I think it might have been fuzzier back then, but I agree right now that there's a reek of self-dealing, and we know enough about fiduciary responsibility these days that you would think that they would steer clear of that. And I think that they are doing that these days, the majority of them. But, kudos to you, because those lawsuits kind of crack them on the head and let them realize what they need to do. Daniela had an interesting kind of gossipy question that I'm into. So you use your research to find a target, but now you do have to get like a participant or a human involved, right?
Yep.
Do you reach out to them, and is that totally legal? And what does that look like?
Totally illegal, and I definitely can't talk about. No, I'm kidding. Yeah. So the process, our cases thus far have 100% been reverse engineered, meaning that it starts with our investigation and belief we found a plan of the problem. We then reach out to people who are employees or former employees of their, either we get their employment information through like LinkedIn, stuff like that, publicly available sources, or we advertise on social media. You know, Facebook, LinkedIn allow you to target advertisements based on what someone's list
Okay,
is their
so
employer.
you go out and you get them,
Yeah.
you find them.
And we just say, hey, our investigation says we think there's a problem with the retirement plan. If you want to hear more about it, and if you have a claim, contact us. Then if they do, then I talk with them and talk about, what we found, why we think there's a problem. And hey,
and you say, hey man, we can sue them. They might settle for like 6 million. I'll take 2 million of it. And then you can have like $500. You want to get in on this thing? Let's do it.
Yeah, that's
something like that.
Usually not the exact phrasing, but yeah, no,
positioned a little better.
I'm super clear on the phone that our fee is up to 1/3 fees. It oftentimes is less depending upon the amount of work we do in the case. It has to get approved by a judge.
No. You're proactively finding these things, Carl. So what do they care what your fee is? If they're disgruntled and have left and they feel there's a problem, just as you are preaching to them, then what do they care what your fee is?
To be quite honest with you, if you work 4 years on something and your firm's dragging in, I've seen some of your settlements, and you're dragging in $1.3 million. Like, I don't even think you're getting a fair shake on the deal, after several years of working on it. So can I ask you more on that? And then we'll shift to a little game here, some fun, but how many do you look at and take an initial step with, and then somehow the wheels fall off and you don't follow it to fruition? Like, what are those stats? Like, how many at-bats and how many strikeouts and how many hits,
That's amazing that you didn't use any acronyms with that analogy. It ends up being, for every good case we find, I probably have swung and missed, at least in terms of looking into it initially, 20 or 30 times. And I should say, when I say it's not first person. Brandon McDonough at our firm is freaking amazing. Steve Iden. I mean, there are other people doing this, and it's not just me. But point being, we have through so many ideas that don't go to fruition. But in terms of even like the cases that we advertise on social media, even then it ends up being less than 50% even have a lawsuit brought, because when we contact participants, part of the reason is to get their 404A5, to write a letter to the plan in order to get the plan document. And we just find that the reason why Nationwide's fixed account, I mean, this is an actual example. Its fixed account was paying like 150 basis points less than the fixed account in the defined benefit plan. And it looked as if, it was self-interested.
150 basis points of revenue. Yeah.
Right. And as it turned out, it had to do with actual very understandable formulas written into each plan. We learned that, we dismissed the case. So, even for things that go so far as to we're going to try to find plaintiffs, or in that case, file a lawsuit, it's more misses than. I heard
Schlichter, I forget where, but talking about all the money and all the time spent, to follow these cases down the path, and all the losses that happen on the ones that you don't keep going. So there is some overhead involved as well. It's not just getting to a settlement and getting, a couple $1 million. You lose a lot of money on the way.
I mean, the risk is, first of all, the risk that Jerry's took is insane. I mean, he racked up in litigating the first Boeing cases, Lockheed Martin, and those first, Tussey, those first cases, he racked up 8 figures of debt, on a credit line in order to see those cases to fruition, because the entire industry lined up trying to just defeat him. And every time he lost, the statute lets you get the other side, says you may have to pay, if the judge decides that they want you to pay the other side's attorney's fees and costs, which is an 8-figure bill. And
have you hung out with Schlichter? Does he have a beer and you have a Kool-Aid and you guys hang out and talk shop?
Well, as a recovering alcoholic, I am not going to have the beer side. Yeah, we co-counseled. The very first case we ever filed was against BB&T, and 2 weeks later, Jerry filed the exact same case. It turns out they had been looking into it for like a year and a half. So we ended up co-counseling with them on that case, and we had a mediation where I got to spend like 6 hours with them.
I think Nick,
You
I
already got,
think
you already
was-
got that
You
one,
got
Nick.
it.
yeah,
You got
Nick's policing himself, which is
Yeah. He's
pretty good.
watching.
He's solid. He's
Legend.
solid. I was actually going to ask you about that later, but I saw whether you guys ever step on each other's toes in cases. But let's have some fun. We're gonna
Come
spin
back to
the
that.
wheel
That's
of
an
ice.
interesting question.
Yeah, we'll get to it. Nick, I want you to pick one of the guys down here. Is the guy with the beanie, the yellow hat, or one of the two, shaved head guys? Which guy do you want to match up with for the wheel of ice?
One of the shaved head guys.
Yeah.
Oh, you get two of them then.
We'll give you Justin because it's landed on Chad like the last 3 weeks in a row. So I don't know if it's gonna land him again. Let's spin the wheel of ice.
Funny how you talk shit on the wheel of ice and then all of a sudden you get it over and over. Like saying something
Let's
yeah.
All right, Mark.
This means Nick
That's gonna be I'm
drinks with me?
claiming at least.
Bro,
Oh, Justin, sorry, Justin, drink your. Or is there a double? Maybe, yeah.
Froze.
My bad.
Froze.
Sorry.
Froze. Yeah.
Damn it.
I gave you a cup in there too. I know you have one.
All right.
You did.
Justin's gonna drink his Smirnoff with his makers in it, and Nick, I'm thinking that's the equivalent of about 4 to 5 swigs for you. So,
Sold.
what is Nick drinking?
What is Nick
He's
drinking?
drinking. He's got a ice ball in there.
Peanut butter whiskey.
Okay, never
Oh.
mind. That's you can do 2.5 to 3. I didn't know you were drinking whiskey. You're good. You're
Too
good.
late, my friend.
No,
Will,
What's that? What's that
Lord's
called,
never going to
Mark?
make it back on the show, buddy.
Screwball. That's it. Thank you, Jeremy.
Carl, so let's go to that. Do you guys ever, you Schlichter, other plaintiffs attorneys, do you both run into you want the same client and do you have to like compete for it? Do you have like say point of sale day where you say, hire me because of this, or do you guys compete with each other?
Like a real estate listing?
Yes, yes, absolutely. The plaintiff's bar is competitive between firms in a whole lot of different areas, and this one's not an exception. And in fact, there are a number of plaintiffs attorneys who primarily make their living looking at all the cases that get filed and finding ideas they like, and then filing the same case, finding a different plaintiff and filing the same case and hope that they get included into the case as co-counsel. So when we were new, we ran into an issue in our second year where all of a sudden a different firm in 2 different cases of ours filed a complaint like 2 or 3 weeks after. And this happened to Jerry as well in like 2007 or something. And what he did is just say, screw you, let the court decide who class counsel is. You end up, there's a motion called 23G fight, and the court has to say who the plaintiff's lawyers are going to be, and or maybe they'll say they should both be them. In securities cases where, everyone's filing on the back of like an Enron accounting fraud or a public event, these things are very commonplace, oftentimes determined by like who has the institutional client, stuff like that. Less so in our cases, but the problem we had was, we had only been around a year. Most of our settlements were all in the area of unpaid overtime. And so we even, called Jerry like, hey, I want a co-counsel just so we wouldn't lose any of these fights. They said no, and we just stuck it out. But now when people try to file on top of us, we just say, go ahead and try, and we'll see who the court sides with.
Yeah,
because
you guys have
$250 million worth of cases. What have you done? So it's less an issue now, but it absolutely happens.
Well, I was on Schlichter's website, and it told me that he's done 1.5 billion on behalf of plan participants. And how much have you guys done?
I think we're over 250 million at this point. I mean, he had a 10-year head start on us.
A big one. Yeah, and he did a couple of big dogs too.
I mean, and look, I'll be the first to admit, look, they are the lead, they are the number one firm, the leader in this area, and it will never be, and that will always be true. And even still, since we're doing it, their they're more leaders in this area than we are. They're the ones bringing the claim that brought the claim about planned data. Now they're the ones bringing the claim against TIA-CREF in terms of cross-selling. I mean, we're frankly less bold than them. We just want stuff we can win. And so we're a little less daring than they are, whereas they're continuing to push the envelope and looking for the newer areas. So, I mean, I will always, take a knee to their firm. I have extraordinary respect for what they've done, extraordinary respect for their knowledge, for the contribution they've made, and for them as lawyers.
Brown noser. What, Chad?
Sorry.
Not all that important. I was just curious if Schlichter hunts the way you guys do. I felt like all of their cases come inbound to them, right?
No, they're doing the same thing we are. And I think although I think they get a lot more intake than we do because they're more famous, but I think the vast majority of the time they're just reverse engineering cases the same way. And in fact, the reason the university case thing happened, because they filed, they sued like 14 universities within like a week, as they thought like we in particular, and I think maybe a couple of other firms would all just sue the other universities. And so they got everything all lined up to drop everything all at once. That was mostly just to keep out other plaintiffs' firms, not to make like a statement, because it's a terrible strategy. Because the thing that defendants love to say is this is another copycat lawsuit, or try to act like there's a wave of litigation.
Yeah, right.
Some judges fall for that and get scared that there's going to be too much adverse implications. They knew that. They just didn't want to have to share.
Well, we're definitely seeing,
they haven't told me that.
We're definitely seeing more of this stuff than we've seen in the past. If you look back 10 years ago, 15 years ago, and then you look over the last 5 years, there's a ton of this happening. Can I ask you, as a naive kind of outsider to the actual process, when you win these days, it's more a settlement than an actual judge winning a case, right? Like very few of these, if any, have gone to a judge in a court and actually, I know these aren't the terms you use in court, but it's always a settlement, right?
Well, not necessarily. We are currently, I would say, 0 for 3, or maybe if you're being generous, 0.5 and to 2.5 in terms of we've had 3 trials and have lost all 3. I mean, and the successful outcomes have been trials. The reason for that is pretty simple, which is that, there's no juries in these cases. It's all a judge. And so when you get a judge who's moderate, I mean, just to be totally blunt, I know we're not supposed to say that there's Trump judges or anything, or Obama judges or Clinton judges or whatever, but there are. And if you get a moderate to left-leaning judge, that is going to give us a fair shake, they'll settle with us. And if we get a Trump appointed judge or a far right leaning judge that they think is going to be very pro-business, they'll just take us to trial. So the only trials we're having are where we have a very bad judge draw and we're trying to overcome that. In one case, we had a Reagan appointed judge in the District of Massachusetts. He found for Putnam, and then the First Circuit reversed him. And then we settled with Putnam for 13.5. So I call that a tie.
This is some crazy shit that I'm learning right now.
Exciting. That's exciting. It's straight out of like TV and the movies, where they're going like, "Oh, this judge going to be favorable to them or not favorable to us," and that impacts your decisions.
They're not making decisions politically. They're not. I mean, they're doing what they think the law should be and following it. It's just that, I mean, left-leaning people point particular judges for a reason, which is that they think that they see the law and the world in a particular way. So when I say, a Trump judge, it's this person is, I did what they think was right, made the correct decision. It's just they have a worldview which is just inherently very pro-business. Right. And it's like, yeah, of course they cross-sold. What did you expect them to do? They were having to compete with Callan and Associates and Mercer. Of course they're going to cross-sell to their clients. And it's, what do you do? So,
and they don't know shit about 401k. Really,
that's a struggle in all our cases, regardless of who the judge is. There's a huge educational component to what we do in terms of how we write the complaints.
It's foreign. It's totally foreign.
Judge and their law clerks about retirement plans.
So here's what bothers me, Carl, is that we're trying to make an impact in this space and create better outcomes and further the industry. And everything I've heard so far is we're going after the ones we know we can win. We're going to settle, preferably, and when we settle, there's no real outcome that is going to affect others because it's not settling in court, right? They're paying out before it gets to that point. and you're willing to drop cases for a bad judge, which means we're not really trying to help the people we're targeting.
Carl's gonna counter you, and he's
Well,
go ahead,
Go,
Carl. Let him
because
know
it
why you're
certainly
making a
doesn't
difference.
sound like that.
let me make two clarifications. First of all, we've never settled a case before it's been filed. So every settlement has been, a lawsuit was filed, it's public, the settlement is public, and nearly every settlement contains injunctive equitable relief, meaning we require the plan to hire an independent consultant or to make
do
actual
certain
changes
things.
to the plan lineup so that there
But that's
is
one
clear-
plan. But does it set a basis? Does it set a precedent that
Well,
others will have to follow?
No, I think the motion to dismiss orders that we got in Deutsche Bank and we got in American Airlines were important cases. Those were ones where they were using proprietary index funds, charging only maybe like 9 bips or 23 bips, but still they were S&P 500 funds. And we got crystal clear orders that appeared to be
Standard and Poor's, Nick.
that appeared to be a fiduciary breach. I think that's played a role in getting rid of some of the shoddy proprietary index funds from the marketplace. And so even though those cases settled, I think that they help.
Guaranteed.
In terms
I
of
think
your
if
other
you
point, which is dropping cases, we've never, ever, nor would we drop a case just because we have a bad judge. We have an ethical obligation to our clients and to the class. If we're appointed class counsel, we will see it all the way through. And so I agree that would be a questionable practice. It's not something that we personally do, but I hear what you're saying, and the way I'm sort of talking nonchalantly about the judges can leave a bad taste.
No, it's real life. You got to play the game smart and strategic. And so it makes perfect sense to me. It's just not stuff that us
We're
common
used to
folk
hearing.
would think,
And I just
about.
didn't know it existed.
So, and what I would say in terms of what we're looking for easy cases is that easy cases on the one hand, what I would also, the other way to put that would be, is the bad actors. In other words, it would be far worse if we were bringing cases against the average plan or if it were random. In other words, my hope is that we do a good enough job in our case selection so that good advisors and consultants, it really helps their business. Like I am very pro professional advice, very pro consultant. And in fact, I would say we've even looked for plans just that are getting their only advice from the record keeper, or that's pretty apparent from the 5,500. They are way more likely to screw up than if they have a fee-based, or just are getting independent advice. So my hope is that by going after the worst acting plans, that we have a bigger difference, because in general it encourages people to do a better job.
Chad, can you imagine a world where, because usually when I see 401k lawsuits, to be honest with you, Carl, I'm in like the anti-shop of you. I'm the industry guy. It's my family's business, started in the 70s. So I'm kind of like, these motherfuckers. But can you imagine a world where there is no 401k litigation? And I think things get real Wild West real quick. And a lot of people are self-dealing, making too much money, taking advantage of situations. And so it's a necessary evil.
What I hear though, just so you know, what I hear, and I'm not saying I disagree with you, JD, and Carl, you supported your points very well. But when I hear of chasing just the low-hanging fruit when we're talking about litigation or issues where there is some significant fuck ups, would be like a police officer saying, I'm only prosecuting, which San Francisco did, felonies. Like, yeah, there's a lot of bad shit. And I recognize that that's terrible, but that's going to be tough for me to prosecute. So I'm just going after these ones that are easy. And that's what bothered me, as you were saying. And clearly that's not the case, but.
Well, I mean, to be clear, there are other firms out there right now, especially who have sort of popped up in the past year and a half, who are filing a much larger quantity of cases and are going after, I would say, not necessarily just the low-hanging fruit. Now, then again, they're looking for plans that are using, higher cost share classes. Some of it is too, though, if I'm over ambitious in terms of what I file a case and I lose right away, the laws move backwards, and it's gotten worse for people because the judge is saying something like, oh, they're fine because they had like 10 other large cap growth options. So it's a free pass.
It's a free pass for everyone out there. They see that and go, oh, we're cool. We're all right.
Yeah. And now, but in terms of what the world's like without litigation, I mean, I think the best example of it is in record keeping prices, which is that like Fidelity didn't want anyone to know what they were paying, right? And it was only kicking and screaming that they even disclosed what those fees were. I mean, I've gotten a cease and desist letter from Fidelity saying that the 404A5s I'm getting from clients are proprietary information. Can you imagine that? Like those ads were like Walmart. It's like, oh, that other grocery store is charging too much for bananas. And the other grocery store being like, that is confidential information. You can't say what we're charging.
And when you're in investments, whether they're private wealth or especially 401k, obviously under the laws of the thing that I will not name, it has to be transparent. It has to be like that. That's only fair is fair. People need to know what it costs. And so I think that's total bullshit. And so I appreciate that has that type of result. So
yes, of course, the 408B2s have helped with that. But I think all of the lawsuits that pled what a reasonable record keeping fee would be and decision that said what plans were charging has played a large role. I mean, record keeping fees have come down since 2009, like 60-70%. I mean, that's not just that's an abrupt change to the market that I think litigation plays a primary role for. So I think it would be the
primary might be a stretch, but it definitely plays a role.
Okay, fair. Can I rescind primary? How about significant material?
Yes, sure. Significant. I like that. I don't know the other word you said. That's above my pay grade. Let's play a game. And then I want to ask you a little bit before. I think the after show is going to be on Fuego tonight, but I'll ask you a little bit about how far down market you all might come. But before we do that, let's Brandon, if we could, let's play that favorite song I love so much, and we will test Carl's skills.
One of these things is not like the others. One of these things doesn't belong. Can you tell which thing is not like the other by the time I finish this song?
Okay, Carl.
It's way better that Nick is no longer inside of a box.
Nick's free floating.
Nick's floating. It's pretty simple. One of these things is not like the others. And we got a little theme tonight. And at the end, I'm going to give you 3 tests. And if you can guess what the theme is, which will be pretty easy, you'll be the golden winner. But which one of these does not belong?
No kicking below the waist doesn't belong. And the theme is rules of Fight Club.
Well, yeah, we'll get to the theme for all 3, but you're right. Yes, it is no kicking below the waist is not a rule of Fight Club. It does not belong. Very good. You are 1 for 1. Brandon, let's go to the next one. Nick, stop playing around. These are 4 movies. You've got Moneyball, Inglourious Bastards. I think I'm getting that right. Tarantino's Once Upon a Time in Hollywood. I think I'm getting that right. And then Benjamin Button is the 4th movie over there. This one's a little trickier.
I think you said it.
Brad Pitt's and all of those.
Well, yeah. So it probably is more about whether he got, I'm going to say Inglourious Bastards, because it's the only one for which he wasn't nominated for an Academy Award.
You motherfucker.
Yeah.
Way to go. Brad Pitt had a nomination.
He should have been.
For an acting, either supporting or best actor in every movie but Inglourious Bastards. That is up there. Phenomenal.
Incredible,
Holy
Carl.
shit. Okay, let's play the last one. I'm so excited. Clearly, we know the theme, right? The theme. You can guess the theme right now.
Yeah,
Sure.
I'm going to go with.
Bang. That's awesome.
I think the answer. Was he? Oh man, it's between Juliette Lewis and Gwyneth Paltrow.
Yeah,
Lewis.
I'll give you that.
Oh,
Juliette Lewis.
Wait. Can I take it back?
Yeah. Probably shouldn't.
The answer is Jennifer Aniston because she's the only one that he hasn't been a romantic lead opposite in a movie.
Well, that could be true. That could be true. He has been engaged to 3 of these actresses, but not Juliette Lewis. So, okay. But you might be right. There's always alternative answers to the one of these things.
Remember whether his romantic relationship was with Juliette Lewis or Gwyneth Paltrow.
Well done. He married Jennifer Aniston. He married Angelina Jolie. He did not follow through on Gwyneth Paltrow, but they were engaged. And
Okay.
he merely dated Juliette Lewis. And the overall theme of these three games is
Brad Pitt.
Brad Pitt. Yes.
So,
Congratulations.
JD,
Well done.
JD, can I ask an important question in regards
Absolutely.
to movies with Gwyneth Paltrow and Brad Pitt? What's in the box? Sorry.
That's a bad ending. Bad ending. Not good. Not a
Yeah.
feel good. Not a
Seven?
feel good ending.
No,
Not a
no.
feel good. Not good. All right. We got a few minutes before we close and then head to the after show. You were on Rick Unser's podcast. I think back in August or something is when it came out this year. And I heard you several times throughout the hour talking about plans as targets and mentioning like a $20 million plan, a $30 million plan, or a $50 million plan, like saying things like they probably shouldn't have A shares, or they shouldn't be doing this or shouldn't be doing that. And I was thinking to myself as I listened, why is he talking about $30 million plans? Does he intend to come that far down in the market?
At this time, there are no official plans to come down in the market to bring any lawsuits against $20 to $50 million plans. Sorry, I was trying to emulate your opening, JD. I think it will happen eventually. So here, the more cases that get brought, the less expensive it is to litigate them. Right. So when Jerry was first starting these cases, he needed like 6 expert witnesses for everything because nothing was law. So he needed an expert to prove everything, how record keeping works, how revenue sharing works, etc. As more of this stuff becomes law, as opposed to it just being something that you need an expert to establish, you can litigate these cases less expensively. Similarly,
It's more efficient. It gets more efficient.
It's a lot harder to write a brief the first time than it is to write it the 20th time. So, and there's more and more lawyers. There's probably now a couple dozen of us out there. Troy, Sean, and Heather, and Jerry's shop. There's probably now 3 or 4 lawyers at Nichols Castor. There's Mark at Capozzi Adler.
You're saying there might be more smaller kind of minor league types that might be willing to, they don't need a big case.
Well, they could, just might go out on their own and just like, hey, because if it's a single plan that's too expensive, all you'd have to do is depose like 3 members of the committee. You maybe have 1 expert who can sort of recycle a report. You could start to litigate against 30, 40, $50 million plans less expensively. So yeah, I don't know what the timeline's going to be, but as of right now, we're
I don't want to give you
almost 7 figures to get to trial. Okay, so it's very expensive. It can get less expensive depending on the type of case you want to bring. We're usually ambitious, so our costs aren't really going down because we're filing big cases and we want big results. But I absolutely.
What's your guys and what's the industry's typical cut of the settlement, like 25 to 35% or something like that?
The max is 1/3. It probably averages to around 25.
Cash
25 and 30%. Depends on where you are.
Dollar bill, yo.
Ninth Circuit, which is California, caps it at 25%. So that's the most you're getting. It just kind of depends on the case, how far the settlement went. So, our settlement against McKinsey was really big, but the case was very new. And so we got, closer to more like 20%, I think. I don't know. I don't really actually touch cases once they settle. Someone else does that.
I didn't know there was one again.
Closer to 10.
What color is your Ferrari? I will tell you this. I do think that when plans are in that 30, 40, $50 million size, they are kind of having growing pains. It's like they do come from products that maybe are A-share type products. And you do get to the point where the revenue that's being generated outweighs the actual costs. And so there is some problems in that space. It's like they're not big enough to like figure their shit out yet, but they're
Yeah.
big enough to have some hangover problems from the smaller micro market.
What I see a lot of is especially where there's a merger, right? So in other words, it was a $20 million plan and now it's a $60 or $70 million plan, and they still have the same broker sold group variable annuity, and with they don't know what the share classes are because because they don't even just, show them on the statement or anything like that. I mean, so absolutely there are a lot of, and the head of my mom's school was absolutely flabbergasted to find out that there were actual fees in the plan when we did a little project to try to gather as many 404A5s as we could, and when my mom asked for hers, they're just flabbergasted. And so and there are still people that don't really know how the plan works. I mean, imagine how much worse it would be if there wasn't sort of the threat of litigation.
Yeah,
So,
fair enough.
I think at this point, it's just on a continuum, which is that at the very biggest plans, everyone is, not necessarily on top of it. I mean, they make different types of bad decisions, but less the asleep at the wheel type. But gradually, the smaller the plans get, the higher the percentage is going to be of plans who are just not on top of how much fees they're paying, aren't really aware of it, et cetera.
True.
And depending upon the scruples of their service providers, are going to be overpaying by some amount. And
True.
So I don't think that there's a point where it becomes terrible. I mean, it probably just gradually gets worse the smaller you get.
I like the way Daniela puts it. There's money in that hillbilly heroin. All right, let's go to Chat Bar Champion. Justin, your vote for Chat Bar Champion.
I'm gonna go Bill Shorey's tonight.
Okay.
Didn't say much,
I'll
but
bet
some
you
of the
he's
shit he
been.
said was very impactful.
I'll bet you he's been banging away on that keyboard, pissed off. Chad.
I'm going Jeremy. Jeremy crushed it tonight.
Jeremy. Okay. Marky Mark and the Funky Bunch.
Can I ask a question before I
Sure.
give my vote? So if we call Schlichter the boogeyman, Carl, what do we call you?
Oh.
Do you have a moniker, or can we officially give you one?
We'll just call him Baba Yaga.
Everyone knows what it is. It's Crazy Carl.
So
Crazy Carl.
I'm just gonna start
Crazy
calling
Carl.
you Nick.
See you die here tonight. Sir, yes, sir. Blue, you're my boy.
Crazy Carl. I like that.
I mean, that's
boogeyman
been
and Crazy Carl.
I've had 4 different groups of people in my life independently come up with that as my nickname for, so sure.
All right,
This
Crazy
would be number 5.
Carl. Who's your vote for Chat Bar Champion?
My answer is that I haven't been able to keep up whatsoever with the chat bar because I'm just trying to follow the
Nick,
conversation.
who's his vote for
Honest.
Chat Bar
I
Champion?
abstain.
Honest answer. How about you, Nick? You got a vote for Chat Bar Champion?
As Carl's proxy, I'm picking Gregory Greenfield, who's been posting
Nice.
and has the most porn sounding name I've seen in a while.
He's a multiple winner of Chat Bar Champion. Many consider
Always
him to
good.
be the greatest of all time, although Daniela might argue with that. I'm going
Hack
with
would be there as well.
I'm going with Hackler just based on some
I
of
didn't
his
get
early.
it. Sorry, I never actually voted.
All right, Mark, what's your vote?
I've been there before, Mark.
Jason L.
Jason L.
Jason
He
L.
said first time watching live too. So
Oh,
hey,
wow.
he's been active.
Okay, Brandon, you've got your plate is full. Hopefully you caught all that. You've never let me down yet. Look at him go. Brandon's on top of it. All right, people, vote for Chat Bar Champion. And if you win, you know what you get. You get your choice of mug. You get to choose Silent J, Nerdy Chad, Robe Guy, whichever mug you want. It's looking like a tight race. Or maybe
Someone
not
in the
so
chat
tight.
earlier said Nick should get a swag bag just for being on here and drinking.
Yeah,
For
we should
sure.
send
Yeah.
Nick. We'll send Nick a whole Retireholics package for sure.
Yeah, you guys
Yo,
closed
congrats.
you guys closed the voting quickly there. Way to
Are we
go,
sharing
Bill.
it? Bill Shorey's Chat Bar Champion. You know what to do, Bill. Let me know in the chat bar what mug you'd like. And I'm pretty sure I have your address. If you think that that's true, then you don't need to private message me your address.
I think we should start keeping track of whose votes win, like whose nominations win the votes.
Oh, like the NFL,
Like they do in like
Sunday?
NFL.
Just more work for Brandon,
Wait,
guys.
Mark, are we out of Acrosin, or do Jess and I have to drink for
Okay.
National Football League?
No, I
right,
think
guys.
that's where the focus should be, because this hasn't been enough about the panelists. So we need another.
We're gonna head to the after show, but
Thanks,
I
Carl.
want to first
Yeah.
thank you, Crazy Carl, for joining us as our guest. We'd love for you to stick around in the after show so we could talk to you more. Otherwise, we just talk a bunch of shit about you. Nick,
Sure.
you for sure can stick around. You out there in the audience, you guys, thank you so much for tuning in to another episode of Retireholics. Next week, we have Scott Buffington from 401kplans.com, which is kind of a cool little record keeper benchmarking tech tool that I was blown away by. And I'm going to do something we've never really done before. Maybe we did it once, is we'll do a mini like product demo, like 5 minutes. Because I want you all out there to check it out. Because I was like, wow, this shit's kind of cool. So Scott Buffington.
Can I flag a question you should ask him? Whether he's ever been hired as an expert witness, or if anyone's ever approached him about it.
Okay, I don't
Tells me
know.
Carl's
I don't know
got
the
some
answer.
insight.
I don't know. We'll talk
Carl,
about that in the after
I'm gonna
show.
call you for
All right,
this.
everyone.
Scott Buffington a real name? How did I get stuck with Carl Engstrom when I could have been Scott Buffington?
All right,
You shouldn't get
Brandon,
Mark
play us
Palmini.
out. Thanks for tuning in, everybody. Thanks to you, Nick. And I'm going to the bathroom, and I'll see you all in the after show in about a minute.
Me too.
What's in the box? What's in the fucking box?